In my last video, I talked about the Louisiana Purchase and the establishment of American governance in the new territory. That example from the Jefferson administration could be applied today to instances of occupying conquered territory and how to move a population that has had a history of despotic rule to being capable of republican governance. Beethoven's Seventh asked me to expand with some detail on that, and to do so, what I'm going to do is I'm going to read from Dumas Malone's Jefferson the President, first term 1801 to 1805, which is the fourth book in his Jefferson and His Time series. Reading from the chapter, The Government and the New Citizens. Louisianans, whom the nation was bound by treaty to incorporate, were not to enter immediately into the blessings of liberty and self-government as enjoyed by the residents of the states or even by those of the neighboring Mississippi Territory. They had been living under what Americans regarded as despotic rule and appeared to have gained only a change of rulers by the act of October 31st, 1803, which provided for their temporary government. The President had assumed the role of despot according to critical Federalists, and his own Attorney General held that his power under the law was virtually unlimited. The Territorial Act that was signed by him about 5 months later and became effective the following fall provided for a government that, while admittedly temporary, was unmistakably autocratic. Even in the more populous part of the ceded province, now designated as the Territory of Orleans, authority was vested in appointed officials and there was no provision for voting. The natural assumption that the settlers in lower Louisiana, who had lived under despotic rule, were unprepared for self-government was reinforced by opinions received by him from that part of the country. Claiborne, then governor of Mississippi Territories, anticipated that the regeneration of the autocratic Spanish system would be an arduous task, and feared that the experiment of sudden and total reformation might prove hazardous. The future governor of the province laid great stress not merely on Creole ignorance of American political institutions and the English language, but also on widespread illiteracy. Jefferson himself, saying that his new fellow citizens were acknowledged to be as yet as incapable of self-government as children, manifested some impatience with those who did not take this into account. Prior to congressional legislation, in a memo that Thomas Jefferson had written to Secretary of the Treasury Albert Gallatin about governance in Louisiana, he had said that he favored at the onset the appointment of a governor and 3 judges, the later to have legislative powers, subject to the negative of the governor and Congress. Such was the case in the first stage of territorial government under the historic Northwest Ordinance, in which the lines of policy had been laid down. In his memorandum he said, quote, "The existing laws of the country being now in force, the new legislature will of course introduce the trial by jury in criminal cases first, the habeas corpus, the freedom of the press, freedom of religion, etc., as soon as can be, and in general draw their laws and organization to the mold of ours by degrees as they find practicable, without exciting too much discontent. In proportion as we find the people there riper for receiving their first principles of freedom, Congress may, from session to session, confirm their enjoyment of them." End quote. He might have rounded out his statement by saying that he expected the inhabitants of Louisiana to become full-fledged citizens eventually, but his expectation could hardly have been doubted by Gallatin or anyone else who knew him well. The main question was one of timing. According to the historic Northwest Ordinance, a territory should pass to the second stage of government with an elective assembly when its population reached 5,000, which Louisiana was exceeding. However, while he may have been entirely correct in his judgment that the new citizens were unfitted for that degree of self-government, he appeared to be showing uncharacteristic disregard of local expectations. He was rejecting the idea of military rule, however, and could have claimed that under his proposals the Louisianians would have more freedom than they had previously enjoyed. In a letter to Senator John Breckinridge of Kentucky, Jefferson recorded his comments on a plan he proposed for organizing the government of Louisiana, and focused specifically on one feature of it. He now favored granting local legislative authority to what was called an Assembly of Notables. On the basis of past observation, presumably in France, he believed that such a body would be more familiar and pleasing to the French settlers than the legislature of judges. Specifically, he proposed that legislative power should be vested in 24 of the most notable, fit, and discreet persons of the territory, to be selected annually by the governor from those holding real estate within who shall have resided 1 year at least in the said territory. In Breckinridge's bill, this body was described as the Legislative Council, and the word notable did not appear, but otherwise the proposals were couched in virtually the same language. In the bill as finally passed, this body was reduced to 13 persons to be appointed by the U.S. President, a thing that Jefferson had not recommended. In setting the bounds of legislative authority, he stated that no law should be valid if inconsistent with the Constitution, that being the U.S. Constitution. He made no direct reference to the Bill of Rights and its guarantees of individual liberties, but he specifically denied to the legislature the power to infringe on the freedom of religion. This was a question of immediate importance in a predominantly Catholic region that was being incorporated into a predominantly Protestant country. In his section on the judiciary, he specified the right to jury trials in criminal prosecutions of capital offenses, stating that this should be extended to other cases by the legislature as soon and under such modifications as the habits and state of the peoples of the territory will admit. He was aware that the inhabitants had had no jury trials whatever under Spanish rule. Though he did not mention the writ of habeas corpus here, he had done so elsewhere, and Breckinridge's addition of it to this section of the bill he introduced was clearly in line with Jefferson's intention. With respect to guarantees of individual rights, however, the President spoke specifically of only freedom of religion and jury trials in capital cases. This was not much, though it was more than the Louisianians had previously enjoyed. At this point, I'm about halfway through the chapter. This is a heavily abridged version, only reading those sections that are relevant to the initial question of how Republican government was slowly introduced transformatively into Louisiana so that it could become, and its citizens could become, fully part of the United States and enjoy all of the privileges of citizenship. So I expect that this is probably going to go for one more part.